good morning to, or good afternoon to you all, even later than we planned. Apologies, bit of technical error there. I'm Robert Kelly from Stewart Title, and we're very happy once again to be running this residential conveyancing forum for you to discuss issues and problems you're finding, and also for us to benefit from Ian Quayle's knowledge. So, as I've already taken up 5 minutes of the time already, Ian, get started,
please. Thank you. Thanks very much. Yeah, my problem with connections this morning, so this afternoon. Sorry about that. Thanks for joining me. We've got lots of things to talk about today. Remember the way this works. You can generate any topic you like to talk about, but I've got some ideas that we can start with. If anyone has any questions, use the chat facility. We can also get your microphone turned on. We do record these events. And again, a massive thank you to Stewart Title for organising this event. So, topics to discuss today. We can skip that slide. We always look at that one. Right. Amendments to Practice Guide 19 and restrictions. Don't know if you saw the amendment to Practice Guide 19 on the 6th of November. What the Land Registry are now saying is that they are not really welcoming applications to modify restrictions, except in quite restricted circumstances. What they're saying to the profession is to use disapplication. And remember, disapplication is a temporary process that prevents a restriction from blocking a disposition in connection with the current disposition, not future dispositions. Modification, cancellation are permanent, disapplication temporary. So again, change in emphasis, highlighting that we should be using disapplication rather than modification or anything else. So have a look at that for me, please. Next thing, BSA update. Two things really to let you know. First of all, the Law Society's guidance relating to the Building Safety Act should be issued early January. I'm trying to get a heads up as to what it's likely to contain. I'm optimistic that it will provide clarity. I am concerned that if it's anything like the Law Society's guidance relating to climate change, we're not going to be that much further forward, but just watch this space on that one. The other point with regard to the BSA that I've been working on this morning, had a meeting at 8:30 concerning the issue of airspace. So what is the position if you're acting for me and I'm buying a flat in a building that currently isn't a higher risk building? So it's a building below 18 meters in height. There is always the potential that the landlord or the owner of the building could redevelop it and build upwards. So if they do that, then what was my current 12 meter high building, six-story building, for example, all of a sudden is now going to become a 20-story building or a 25 meter height building, whatever it is. Okay. In those circumstances, that then becomes a higher risk building. Well, so what is the cry? Well, so what? One, that would mean there'd be implied terms, implied covenants into all residential long leases. So I'm now in a situation where I'm having implied into my leasehold into terms, courtesy of the amendment to the Landlord and Tenant Act 1985. And secondly, and significantly, I've got a situation where, because of the additional duties and burdens being imposed on the landlord, my service charge is likely to increase quite dramatically. So that's something just to watch out for. It's an issue for developers. It's also an issue for leaseholders in buildings that currently are not higher risk buildings. Could the landlord convert that building into a higher risk building and thus generate implied terms into my lease and also generate a risk of increased service charge costs? Now, Zara just raised something. So the BLG forum as to what we'd like to see in the guidance note from the Law Society. I think the problem, to be honest with you, and the reason why I'm not that optimistic that it's going to be the magic fix, is because the Act itself is so complicated. The regulations and the Act are to an extent confusing, and therefore what the Law Society has to say about how the Act how the Act actually operates for practitioners might not be a lot of use. So, for example, again this morning, I was doing some more work on the production of a leaseholder deed of certificate. And again, I know it's a point that Zara always asks me about. You know, why am I saying that you shouldn't serve a leaseholder deed of certificate on a landlord? Well, the reason I'm saying that is because that immediately brings into play paragraph 13 of Schedule 8, which then means that I don't have to worry about ownership or occupation as of the 14th of February 2022. But Zara would say, another practitioner would say, is look at the government guidance notes about leaseholder deeds of certificate, and I was just reading it this morning. The guidance note says the leaseholder deed of certificate should be served on the landlord. Now, I maintain it should be served on the landlord where the landlord asks for it, but it shouldn't necessarily be volunteered. So I'm going to be emailing the government today about this change to the wording of the guidance, because I don't think it should say that it should be served. I would say it may be served, but there may be a disadvantage in doing so. Other issues with regard to the Building Safety Act, again, doing a lot of work with regard to landlords and higher risk buildings and the implied terms and the additional burdens on landlords with regard to the management of higher risk buildings. And again, with regard to a landlord certificate, I don't know if you saw the recent case, but the first year tribunal has said that they cannot compel a landlord to serve a landlord certificate. So there isn't any sanction, direct sanction on a landlord for failing to serve a landlord certificate. There's an indirect sanction in that it is deemed, the landlord is deemed to meet the contribution condition and therefore is obliged to meet remediation costs for relevant defects out of its own pocket. The other point on the BSA as an update is our book is now with the Law Society, and we're hoping it's going to get published sometime early in the new year. Our fingers are crossed that the Law Society guidance won't require us to radically overhaul what we've done. Anyone got any sort of burning issues? Zara, if you're a qualifying leaseholder, would you not offer this? Yeah. Well, Zara, again, I'm with Howden tomorrow, Insurance Brokers tomorrow on this, and we're doing a series of podcasts on the Building Safety Act. And I can tell you that Howdens are saying that insurers will insure firms that are doing Building Safety Act work. Zara, have you not seen the sort of the wish list that insurers are asking for with regard to professional indemnity cover? I've got a wish list of what they're saying. For example, they're suggesting that you put a cap or ceiling on the number of transactions that you're dealing with that are BSA related. So they're saying that, you know, a firm that says, hey, we'll take on any BSA related work and are being bombarded as a consequence are high risk. But they're saying if you're doing residential leasehold work, some of which involves the BSA, then that's acceptable. They're also saying that you need to be robust with regard to your retainer and your report on title. I know that I did some work for the CLC with regard to wording, which Howdens like and which they've approved. And the other thing is we've got flowcharts that Tanfield Chambers and I have produced, which are still for sale. They've been revised and they can be bought, which again provides you with a path to act for both a seller or a buyer where there's BSA issues. Zara, you're quite right. Yeah, a wish list isn't you can't waive that when a claim's being brought and said, right, that's a defence to an allegation of negligence. I guess that. But the point I'm making, Zara, is that they are trying to be helpful to say, you know, you can act. Thanks for that. Selena, great question. The disadvantage of a leaseholder serving a leaseholder deed of certificate if they're selling. If you serve that on a landlord, what you're doing is you're immediately preventing you as the current seller or subsequent owners from relying on paragraph 13 of Schedule 8 of the Building Safety Act. Paragraph 13 of Schedule 8 of the Building Safety Act says that there is a presumption that your client's lease is a qualifying lease if you can establish that the landlord doesn't have your leaseholder deed of certificate and the landlord hasn't asked for it. And when I talk about asking for it, I talk about taking prescribed steps under the Act or reasonable steps under the Act to seek a leaseholder deed of certificate. So if that applies, then you don't have to worry about condition, I think it's section 117D, that says that the owner or occupant of a flat or apartment as of the 14th of February 2022 has to have this property as their principal home or has to own this and no more than 2 of the dwellings in the United Kingdom. Selina, it's that's causing people problems with regard to leaseholder deeds of certificate. That and the height issue, which is a separate issue. But if we can establish we've got a relevant building, then if we can establish the landlord hasn't got a leaseholder deed of certificate, nor has the landlord asked for a leaseholder deed of certificate, then we automatically have a qualifying lease due to paragraph 13 of Schedule 8. Does that make sense, Selina? Now, the problem is that if you look at the government guidance, it states, and this is Zara's point, that you should serve the leaseholder deed of certificate on the landlord. And I say you should serve it if the landlord asks for it. You've got to do that. If you don't, you lose your qualifying lease status. But if you've got a leaseholder deed of certificate, I'm imploring the profession to simply make that available to the buyer, and for the buyer and you to hope the landlord doesn't ask for it and the landlord hasn't got it in its possession. To do that, you need the seller's conveyancer or the seller to confirm we haven't provided it to the landlord, and you need to check the LPE1 to make sure the landlord isn't saying I've got it or I've asked for it. Okay, so let's just have a look at some of these points. There's loads of questions. Right, okay. Claire, if a company is the owner, can they be a qualifying leaseholder? How do they answer the question about ownership? Well, there's different views here, Claire. The view I've currently got is that a company can be an owner of a qualifying lease. But as you rightly say, the ownership occupation point, can that be answered by a company? That's my issue. Claire, I'm going to have a look at that and I'm going to come back to you, okay? Because I need to do some work on it. Now, someone's got their hand up at the moment. I'm just going to have a look at who that is. Zara, I think you've got your hand up at the moment. No, you haven't. You've put the thumbs up. Sorry about that. Right. Davina. Yeah. Again, Robert and I were talking to Fiona, weren't we, yesterday, Robert, Department of Levelling Up, and she was telling us that they are successfully leaning on lenders to ensure that they're relaxing their instructions. Fiona said to us both yesterday that where we're talking to practitioners, we should tell practitioners to write to the Department of Levelling Up if a lender in their Part 2 instructions is asking you to verify the content of a landlord certificate or leaseholder deed of certificate. What they should be asking you to do is to confirm that you've got it, not asking you to confirm the content. So, Davine, let's have a look at this question. The problem is, though the Part 1417 requires us to request both a landlord and a leaseholder deed of certificate. We need to request these in order, but the point there, Davina, is it doesn't say who you've got to ask for the leaseholder deed of certificate from. The landlord certificate and the leaseholder deed of certificate should be produced by the landlord or the seller. Okay. And the landlord certificate should be issued to the seller and then produced to you, or the landlord certificate accompanying the LPE1. As far as the leaseholder deed of certificate, I want that to emanate from the seller, not the landlord. Does that make sense, Davina? Well, Zara, right. Important point. Excuse me. Firstly, a leaseholder deed of certificate is a golden ticket. Okay, so clients have to have drummed home into them that this is an important document. Okay, potentially critical in connection with subsequent sales. Okay, and it's not just the sale from the current owner to the buyer, but subsequent sales where this document is potentially some protection for some remediation costs for some defects. Okay, so right, so they can hand it down. Now there was talk that the land registry would act as a library for leaseholder deed of certificate. I don't know how far that's gone, and I don't know whether that would work. Right, so yeah, Davina, you're requesting this document, but you're not requesting a leaseholder deed of certificate from a landlord. You should be requesting it from the leaseholder. The landlord produces it. Hey, that's fine. If a leaseholder has served it on the landlord, that's fine. But all that does is remove the potential for protection under Schedule 8, paragraph 13. So, Joe, would it be acceptable to the lender? Depends on the lender's instructions. Okay, and yeah, one of the problems I've got at the moment, and one of the things I need to do, is to see if we can get some form of forum with lenders to explain about how paragraph 13 Schedule 8 works, because it means that you don't have to worry, I repeat, about whatever the seller is saying about ownership or occupation as on the 14th of February. It matters not. As long as I can confirm this is a residential long lease, as long as I can confirm there's an obligation in the lease for the leaseholder to pay service charge, as long as the lease is dated or granted before the 14th of February 2022, and I can confirm this is a relevant building, then that presumption means I don't have to worry about ownership or occupation. Now, the issue of height is a separate issue. And what I'm saying to practitioners about that is, if a building has been registered as a higher risk building with the health and safety executive, then that's evidence that the building is more than 18 metres in height or more than 7 stories in height, which automatically means it's a relevant building more than 5 stories in height or more than 11 metres in height. The problem with the register of higher risk buildings is that it's not a public register, but you could ask whoever registered the building as a higher risk building for proof of registration. And in that case, you've got confirmation that this building is more than 18 metres in height and more than 7 stories in height. But other than that, you're entirely reliant on third parties telling you the height of the building, which is why you can't verify to your lay client or a lender client the height of the building and whether it's a relevant building or a higher risk building. So Claire, let's have a look at this question. I'm acting for a buyer. Seller has served a leaseholder certificate. So served on you, Claire, or served on the landlord? Freeholder refusing to provide a landlord certificate. Right. Claire, I repeat, a landlord does not have to serve a landlord certificate. But if a landlord doesn't serve a landlord certificate, it is important to understand that creates an advantage for the seller and the buyer. The advantage is the landlord cannot claim for remediation costs for relevant defects that it is aware of prior to the date of the landlord certificate. So we get a free pass as the leaseholder, and we're not liable for our contribution towards that remediation, no matter what. Okay? If the landlord did serve a landlord certificate in time, then the position is that we still have some protection, courtesy of Schedule 8 of the Building Safety Act. So we don't have our get out of jail card, but we have some protection anyway. So that's why, and again, government was talking about this yesterday, you shouldn't be screaming at landlords to issue a landlord certificate. What you do is, has the leaseholder, the seller, notified the landlord of their intention to sell? Tick. Have I got evidence of that? Tick. Can I confirm the date of that? Tick. Diarise 4 weeks. If landlord hasn't served a landlord certificate within that 4-week period, happy days. Previous remediation work irrecoverable. Landlord can still issue a new landlord certificate for later discovered remediation work, but he's stuck with regard to that old cost. Okay, so don't ask landlords or don't ask sellers to chase landlords for landlord certificates. Because if the landlord doesn't serve it, I repeat, the landlord is deemed to meet the contribution condition in Schedule 8, meaning that the landlord is responsible for remediation work for relevant defects. Now, if you look at what Claire's saying, she's saying there's a right to manage company saying remediation work may be undertaken. Right. Now, depending, if this building is more than 18 metres in height, Claire, or more than 7 stories in height, it becomes a higher risk building. If it is a higher risk building, then in addition to the landlord or freeholder, anyone that's responsible for repair or maintenance of common parts or structure becomes an accountable person. And they are responsible for building safety measures relating to their part of the building. The accountable person would be under a duty to notify the landlord about that remediation work. And the landlord should be serving a landlord certificate indicating that that work needs doing. If he does that, then the cost that's incurred can be recovered. But in this position, unless the landlord serves a landlord certificate on you, then the position is that the landlord can't transmit that cost. If the right to manage company is incurring the cost, then the position is the right to manage company isn't a landlord. It can't serve a landlord certificate. All it can do is transmit information to the landlord concerning that remediation work. And in those circumstances, if the landlord doesn't serve a landlord certificate within time, the position is that the right to manage company might have a right of action against the landlord in connection with these irrecoverable costs. It can seek what's called a remediation contribution order via the first tier tribunal, Claire. Does that make sense for you? Hi, Joanne. Right. Yeah, the CTX issue. I was just looking about that this morning. It's a nightmare, isn't it? Okay. So can I ask, given that we've got this, what sort of backup systems have we got if there is a failure like this? Or am I being naive and there isn't a backup system, Joanne? Because it seems to me, you know, in everything that we do, we're required to have policies and procedures in place to deal with this sort of situation. So if you look at CQS and you look at sort of SRA guidance, the idea is that we've got a fallback position. So why isn't there, Joanne? You know, it is horrible for these firms and awful for clients, but is there not some form of fallback? So while we're waiting for that, Davina, our request could prejudice have to come. Yeah. Well, exactly right. So what you would say in that situation, well, Davina, what I would do in that situation is one, email the Department of Levelling Up and say, look, I've got this problem. Can you lean on the lender to relax their instructions? If the lender won't, you've got to say to your client, look, I'm obliged via the lender to do this. In doing this, this is going to generate potential problems for you, and your position could be prejudiced as a consequence. Now, the problem there is if I'm a client, I'll say, well, all right, tell me about what this prejudice is, please. And the problem there is that Schedule 8, the issue about paragraph 13 and the presumption is that we're then not in a position where we're reliant on whoever produced the leaseholder deed of certificate telling us the truth about their ownership and occupation position as of the 14th of February 2022. If they deliberately lie or get things wrong with regard to how many other dwellings they owned or about what their position or status was as of the 14th of February 2022, if they get that wrong, and the landlord finds out, then that leaseholder deed of certificate is void, and the Schedule 8 protection that we thought applied to us wouldn't apply. So that's the position there. Does that make sense, Davina? Zara, if leaseholders start registering their deeds, would it not possible for landlords to download it? Well, yeah, it would. But then the position is that the Act states, Zara, that landlords have to take prescribed steps or reasonable steps to get it, or it would have to be in their possession. So the issue would be, did the landlords have it at the point of transfer, I think. Okay, right, Lisa. Yeah, right. Now, again, that would mean, Lisa, that the landlord certificate is incomplete and therefore invalid. So the point here is the failure of the landlord to provide that information would mean that the landlord certificate is ineffective, meaning that what I said applies. The landlord is deemed to meet the contribution condition, and therefore there's some protection in connection with historical remediation work, Lisa. Does that make sense? Yeah. So, right, let's have a look at it. Can't figure out whether buyer would potentially qualify for any protection. Well, let me explain this, if I can, Lisa. If you look at Schedule 8 of the Building Safety Act, it says where a landlord or an associate of the landlord, and this issue about what the associate of a landlord is very complicated, but basically there's a connection between the two, put simply. In those circumstances, if a landlord incurs a cost remediating work that the landlord or an associate did in the first place, no matter what sort of lease you've got, as long as it's a relevant building, the landlord can't transmit the costs. The rest of Schedule 8 protection applies if you have a qualifying lease. So a qualifying lease would mean a landlord can't transmit costs relating to cladding into service charge, would be capped at £10,000 or £15,000 dependent on where the flat or the apartment is. And if the flat or probably had a value below, is it 350 and 175 outside of Greater London, again, the landlord can't transmit costs relating to remediation work for relevant defects. Yeah, there's guidance on this, Zara, about the landlord certificate. But in essence, if a landlord gets it wrong with regard to their financial status, so it states that it doesn't meet the contribution condition when it does, or if a landlord fails to disclose remediation work that it's aware of, then as I understand it, the landlord certificate is void and unenforceable. So immediately, landlord deemed to have met the contribution condition. A landlord can always issue a new certificate, I repeat, in circumstances where the landlord becomes aware of new remediation work. Right. Zara's second question. Thanks, Zara. If we have established the landlord hasn't replied in time, how do we record this, give the client, so that if they end up with a bill from the landlord that smells like they may have remediation charges in it, how does the individual leaseholder fight it? Well, he fights it by application to first-tier tribunal, Zara, and there was a case recently where that's exactly what a leaseholder did successfully. Okay, so I think what you say to the client is the landlord had a request made on whatever date it was by the seller, we assume, and we've got a copy of the seller's email, so we'd be raising inquiries of the seller, additional inquiries of the seller to provide confirmation as to when the landlords had a request for a landlord certificate or when the landlord was notified of the seller's intention to sell. We have that evidence. We diarise when the 4-week period expires, and we say to our client, this is when the landlord was asked to produce a landlord certificate or was obliged to produce a landlord certificate and the landlord's failed to do so, and therefore the position is that the landlord cannot recover remediation costs for relevant defects. You'd have to explain what a relevant defect is. Remember, a defect that's less than 30 years old and relates to a fire safety risk or a risk associated with the collapse of a building. So that's how you deal with it. Yes, Selena, the request, could prejudice your client's position. So there is a potential conflict of interest there, Selena, isn't there? So, I mean, so what I would say, Selena, starting point, Department of Levelling Up, help, okay? And I'm told that they are being helpful, and I'm told they're being very receptive to that sort of application. So you've done that. Lender is still saying, no, I want it. You say to your client, look, either we proceed on this basis, or you find yourself another lender, or you're aware of risk. Remember, our task is to highlight risk, not to assess or determine the extent of that risk. Joanne? So you don't know if there is one. So what's that, Joanne? Yeah, so Zara's saying CTS, there isn't a backup. Right, Jaspreet, just remind me, MI from agents. Let me know about that, please. Claire, I have a not fully complete. Yeah, it's a defective certificate. You don't go to the landlord and say, hey, that isn't right, or that's incomplete. You just say, thanks very much. You know, you're under no obligation to invite the landlord to amend it. Okay, you can go to first tier tribunal for an order that the landlord certificate is incomplete or defective. But I repeat, a tribunal cannot and will not compel a landlord to produce a landlord certificate. They don't have to. A landlord could say, I can't generate all this information in 4 weeks. I'm wasting my time. I've got 2 accountable persons, a principal accountable person. It's going to take me months to produce a landlord certificate. So, hey, I'm not even going to bother. Or I'm seeing some landlords are saying, this is commercially sensitive information, so I'm not going to tell you about my company's financial affairs. Get lost. And I appreciate them telling you to get lost. I'm going to now take the hit, potentially, with regard to remediation costs. I was talking to a landlord last week, and the landlord had said, look, I've checked thoroughly, and I'm convinced that there isn't any remediation work that I need to do in connection with my building. I've also got a complicated situation with regard to my company's finances. The cost of getting an accountant to produce a report as to whether we meet the contribution condition or not is going to be a lot of money. I haven't got the time, I haven't got the inclination to do it. I'm taking a tactical position here, and I'm just not producing landlord certificates. So I've got that. I've got other landlords that are saying, look, what we need to do is produce information and have it like a stockpile of information, so that the moment we get a request for a landlord certificate from a leaseholder, we've got everything on file. Now, one of the things that you've got to do is assess the financial status of the landlord as of the 14th of February 2022. So it's not just the financial status of the landlord today, it's their financial status those years ago. So we could amass that, couldn't we? As far as remediation work is concerned, we can, as and when we're getting information in about remediation work, have a system on our system that means that we can upload that or have it in a format that we can put it in a landlord certificate when required. Yeah. Right, Zara, yeah. Okay, right. Problem with that not having a landlord certificate or leasehold deed of certificate is again the risk of not being able to say what the work is required. Yeah, well, Zara, you're back in the point I make about scoping your retainer, right? You tell your client, Zara, I cannot give you any advice concerning the state and condition of the building in which your flat or apartment is situated. There may be remediation work that needs to be done that falls outside the Building Safety Act, which can safely be transmitted to you by way of service charge, subject to the normal statutory protection that's afforded to you. There may be other work that is classed as remediation work for relevant defects as prescribed by the Act, where Schedule 8 may provide you with some protection. Okay, that's the issue. Right, now then, Lannis is fully complete, dealt with that. Jaspreet, right, material information, HIPs, supposed to get, yeah. Right, great question. Thanks for that, Jaspreet. I thought that's what we were on about with the Carter MI. So what are we doing, folks? Anyone getting requests for material information? Thanks, Jaspreet. So anyone getting anything from there and what we're going to do about it? What do we think about it? Zara hasn't encountered. Anybody else? Joanne? Anyone? Anyone getting any information on this? No, nothing to date. Okay. To be honest, Jaspreet, it's off my radar at the moment. I've got so much washing around, including the new leasehold legislation, including some new law society stuff coming out in January, isn't there? And I can't even remember what that's about, to be honest. I've just started looking at it. Yeah, okay. So do we know when this goes live? Yeah, nothing's been issued yet. Okay. So, Jaspreet, are you concerned about the fact you've got to provide this information? Are you worried about how the fact this information is being produced requires then what work is required from you with regard to due diligence? Is it that sort of thing? Or why is it on your radar, Jaspreet? But as I say, no one seems to have anything sort of startling about it at the moment. So while I'm waiting for that, Robert and I did a Scottish forum. Stephen and I did a Scottish forum last week, and we saw, well, I saw for the first time, some standard conditions relating to a seller selling a property with the benefit of defective title insurance. And again, I was thinking that's useful. What I'll do is dig a copy of it out to let people have a look at it, but it just raises an issue about being careful where there are pre-existing policies, either to get warranties from the seller with regard to what they've disclosed to the insurer, or you perform a due diligence exercise with the insurer to see what has been disclosed to them or what they're aware of with regard to the policy. Jaspreet's got back to me. Hi, Jaspreet. A lot of people raise it and I was unaware of it, hence the query. I saw a bit of on it on Jaspreet, but I haven't done anything on it really. There is a group, isn't there? Zara will know about this. I'm sure there's a group working on this, like a working group, who are looking at it. I think the Law Society is as well. Right. Property Lawyers Action Group, thank you very much. Peter thinks it's going to speed up the home buying and selling process. May work with freeholds, not leasehold. I agree. Well, it's like home information packs, isn't it? It's sort of a new version of that. And again, did that work in the good old days? Did it just mean there was some information, but buyers, conveyancers just continued boldly on with performing due diligence as they always had done? I don't know. It's an interesting thing. What we'll do is perhaps have a look at that in connection with the next time, Jaspreet. So I'm going to have a look at material information for our next meeting in the new year. Okay, right. Okay, thanks, Mark. Disclose the post general auction pack breach. Yeah, that's the issue that I've come across a lot. Thank you for that. And hi, Christopher. Mark, yeah, you're right. In a non-invalidation clause doesn't mean successor is not prejudiced by non-disclosure. Robert, have you seen what Mark's saying there about this idea of non-invalidation clauses?
Yes, we have got that. I've seen that in various cases, but both of those points that you raised and Christopher raised are general ones which we try to drill home to people when we're talking to them. Certainly an auction pack is regarded as throwing the policy out to the world. And in the paranoid world that some of us insurers live in, we believe your neighbours will be straight down the auction house to see about your title. So you can't disclose it without approval of the insurer. And obviously, one way that does sometimes get disclosed is where you've given standard replies to inquiries and refer to it in there. So there is wording which we can recommend in those cases if you want to put it in there without disclosing the policy. But on the point you raised and those clauses which we saw from the Scottish contracts, again, a really important part. An insurance policy is not a magic wand. It's not a get out of jail free card. It is a contract. And the way that contract was negotiated is shown in the proposal and in the information, whether that's merely ticking boxes online or actually answering emails from the broker or from the insurer. So you do need to know what was in that proposal to really take any comfort from an existing policy. And I'd not seen anything until we saw that last week, the Scottish wording. So we are working on a newsletter to clients, just recommending that and seeing, because I can't see any good reason why it shouldn't work in England and Wales as it works in Scotland.
I agree. Robert, while you're on the line there, can you tell me, we were talking the other week about you've got a new system, haven't you, for sort of policy issues or for applications, a new platform or something? Am I dreaming?
We've spent the last year or so just we've just spent the last year or so just really working on comments which people have made in forums like this and also directly to us about our online ordering system, Stewart Solution. So we have now simplified it, I think, added variable assumptions of fact. So you can now tailor the policy more directly to your property, and it should now mean that very few policies need to come offline. So we will be sending details of it out with the recording of this one, and also a little video walkthrough. It's not quite the John Lewis Christmas ad, but I think it's something to look at and enjoy, because it does show you how easy the system is to use and to get the benefits quickly, get a draft policy and quote in really less than 90 seconds.
So for your clients, it's a tweaking of the existing system rather than something that's scary and new. Would that be fair or not?
Exactly right. Yeah, the login details remain the same. Everything is the same. We've just really responded to questions that people have raised and comments have raised in the last couple of years to make it reflect what you need better than what our PD people think you need. Yeah,
got it. All right. Thanks for that, Robert. Thank you. Just going back to Joanne. Hi, Joanne. Yeah, defect always had a special condition, seller confirmed statement of fact or whatever they call it, specific to the policy. Yeah, great point. Right. Yeah, the accident crisis. I agree, Zara. Fight additional charges. What happened to Fiona? We had a meeting with her, Zara, and she's going to come along. We're going to have a forum. I think it's the 14th of December, isn't it, Robert? Everyone's welcome.
It is. It's the 14th of December. It's rather late in the day. It's at 3 o'clock until 4, because we thought we'd allow Fiona to have a last lunch before we threw her to you all to be consumed. But we will be sending out details in the next couple of days about that. The idea is if you can send in questions beforehand, then we'll put those together and get some of those answered and then open the chat after that. But it should be really interesting. She's very keen to put over the government's case, and it does sound like there is more happening there than perhaps we're aware of down here. So 14th of December, 3 o'clock, and we'll send out details to you in the next couple of days.
Yeah, certainly, you know, Fiona's been very helpful and very sort of open and willing to listen to both Robert and I. I've had a few meetings with Fiona now, and happy to come along, which is great. I tell you what, I haven't talked a lot about this, but I'll try and get someone from Tanfield Chambers to come along in January and talk to us about some of the work they've been doing, because that's quite interesting. So great. Okay, so thanks for that, Zara. Right, online auction tips for buyers and sellers. Just some comments to note. Sellers need to be careful because a lot of the online auction houses shift liability in connection with misrepresentation or misdescription. So they say, look, we're not liable, right? Which I think means that if there is a misdescription or misrep, then the likelihood is that the action will be brought against the seller. So I think in auction houses ducking liability or responsibility, there's greater risk to the seller. And from a buyer's perspective, two things. One, be careful if you're acting on behalf of a buyer where there are perhaps a group of buyers creating a sort of a team, as it were, to buy property online. Who are you acting for? And do you need some form of joint venture, some form of partnership, or at the very least, some form of sort of basic declaration of trust with regard to the person that is actually bidding on behalf of the consortium, what he's bidding for, who he's bidding for, what his sort of limits with regard to bidding are. Because I was reading about a matter where someone was acting as sort of part of a family association that was buying a property, was a successful bidder, but then decided the property was so cheap that he didn't need other members of the family to assist funding it, and it was such a good deal that he wanted to keep it for himself. And there was some litigation as between them. And then my thinking is, well, if that's the case, what about the conveyancer that's acting on behalf of the successful bidder? Was he aware of these other parties that were involved, and what's the issue arising from their litigation as far as that conveyancer is concerned? There's all sorts of issues about knowing your client. There's all sorts of issues about risk in connection with the third parties that are sort of outmaneuvered with regard to that transaction. And the other thing with acting for buyers on online auctions, watch, because sometimes the administration fees that the buyer is paying are deducted from the purchase price. Sometimes they're added to the purchase price, and sometimes you could have a situation where your client is successful at an online auction, and therefore that success enables him to proceed to exchange, giving the client the opportunity to not exchange. But in those circumstances, the position is that the fees that are being paid are lost if the buyer is unwilling to proceed to exchange. So you might think in some of these online auctions, highest bidder has sort of an escape route, so it doesn't have to exchange and complete. But in following that escape route, they can lose some of the fees that they've paid in connection with the auction pre becoming the successful highest bidder. Do watch out for that. Zara, thanks for the Property Lawyers Action Group. Thanks for that. So what else have we got? Robert and I were talking the other day, and I was talking to someone else about this yesterday, about the market. Are we, do you think, suffering? Is there a slowdown? Is the slowdown just because those that were wanting to complete by Christmas have got their ducks in order and the transactions are progressing? Those that have missed the boat are now saying, right, we'll wait to the new year. So there's no rush to instruct lawyers, no rush to sort of find a property. Let's just back off. Are you finding that some people are backing off on the basis that the market's in a bit of turmoil and they're gambling on prices falling? Just what's everyone seeing with regard to instructions? Are we getting lots of instructions? Are you getting instructions that you're comfortable with? And where there is a dip, you're putting that down to the time of year? Or do you think there's something more sinister? Or should we be more optimistic for next year? Talking to someone this morning, their attitude was that there will be a sort of bit of a dip, but then they're of the view that once we see there's an election, once we know things get stabilized, then the market will pick up. So let's just have a look at this. Slow down instruction generally, bottom level of the market stuck, yeah. Rising interest rate, lack of time. So building safety issues still a problem, says Zara. Yeah, I get that. Joanne, normal, okay. Selena, investor buyers, okay. Selena, you don't have to, but roughly where are you? Is this international work that's coming in? Is it London orientated, or what are you finding? Or are you in a hot spot? Yeah, so nothing major. Oh yeah, all right, Selena. So you're seeing that. That's interesting, isn't it? So that market's back again, okay. And Gesundering, yeah. pulling a fast one last minute, dropping the purchase price. And what's happening, Zara? Are sellers just saying, well, hey, you know, bird in the hand's worth two in the bush or whatever, or saying get lost? What are people doing there? That's interesting. So it seems to me, looking at this, that we're all moderately happy about next year. No one said to me, we're terrified. See, I was talking to someone a couple of weeks ago and they said, oh, we're thinking about laying off staff and we're doing this and doing that. And I'm thinking, crikey, that's bad news. Yeah, Catherine, thank you. Chains all being ready to get exchanged. Right, okay. No problem, Sue. Hey, listen, Sue, have a lovely Christmas and New Year if I don't speak beforehand, and we'll give you details about what we're doing in the new year. But thanks for your contribution, and I'll pass on the message to Stephen and Robert from Stewart Title. Joanne, streamlined, happy if we could win the lottery and leave the law. Well, yeah, Joanne, me and you both. Yeah, it's tricky, isn't it? Streamlining, yeah, I get that. I'm ever the optimist, you know. I always, well, there's two things. One, I always think there's a base level of work no matter what. And when times are tough, you know, people are selling houses or relocating with work. So I sometimes think that you're expecting real doom and gloom, and what happens is we're not having the same sort of peaks and troughs that you might get. I remember with commercial property, I think that it's radically different in that you do see huge peaks and huge troughs, depending on the economy, depending on availability of funds, etc. With resi, I think there are peaks and troughs, but they're not quite as pronounced. And as I say, I think once we know when there's going to be an election, once the dreaded BSA gets sorted out, then I think, you know, we'll get back on to what I would class as normality. When I talk about normality, I talk about pre-COVID levels of work. I think during COVID, SDLT, holidays and all that goes with it, the whole world went crazy. Right, Zara, facing delays on leaseholds. Fire safety, yeah, having to fight to get them to landlords, yeah. Risk assessments, problems are, I agree. Someone sent me an email yesterday and we were looking at the Fire Safety Act and the Fire Safety Regs. And I was explaining that, is it the Act or the Regs refer to 2 units with common parts? So the Regs apply, but the Act doesn't, or vice versa. Can't remember, to be honest, Zara. But yeah, that's an issue, isn't it? Okay. And do you think we're going to get sorted out with regard to the problems with the software that we were talking about a little earlier? Do you think that's going to get resolved quickly, or is that a sort of slow burn? And has anyone else got any topics to talk about, or what would you like to talk about next time? So we're going to talk about MI, as Jaspreet asked. We'll have a look and see if we can get a heads up with regard to Law Society guidance. We'll see if we can get someone from Tanfield Chambers to come along and to talk about the BSA a little bit. We've got Fiona coming along on the 14th of February, and we're all invited to that, which will be interesting. Similar issue, 3 weeks now, and you've got access to systems again. Yeah, thanks, Selena. That's scary. And again, you know, it's like everything else, isn't it? You know, do we have a backup system? Do we test it to make sure it works when we have to test it, or we have to check? Okay, good. Yeah, the exchange formula. I'm going to have a look at that. Yeah, right. Jaspreet, yeah, the exchange. That was something I was going to talk about. So I will be doing something. I'm probably doing a webinar on that in the new year, and we'll talk about that. Priority of mortgagees. Yes. Christopher, happy to look at that next time. Made a note of that. And whatever else you want to talk about, you know, happy to look at it. The leasehold reform legislation and estate rent charges and rent charges, we'll talk about that as well. Yeah, I was just mentioning Zara, great minds think alike. We'll talk about that and we'll have a look at that. And we'll just see what else is coming along. So listen, I'm conscious of time. And once again, what I'd like to do is to say a huge, huge thank you to Stewart Title for organising these events. We do a lot of them. We do them for commercial property lawyers, for support staff, for local authority lawyers. We started doing them in Scotland as well. And they really, really are popular. And we're getting more and more numbers and more participation. It's funny, when you start off, there's not much participation. Once you get a group like we've now got in England, it's brilliant because there's so much stuff coming through all the time, which makes it really great. And remember, these are your events, so you don't have to let me know during the event that you've got a hot topic or a problem or issue. Send me an email. Even if it's something that perhaps isn't relevant to this, it might give me an opportunity to have a think about training, or might get me scurrying off to do some work. So, Christopher, you're interested in equitable and legal mortgages as well. Yeah, let's do something on that. That's an interesting topic. And remember, talk to Robert, talk to Stephen at Stewart Title with regard to your needs, and have a look at their new platform. And all that's left for me to do is to thank you once again for giving up your time today. Thank you for your support for this event, and for Stewart Title for inviting me along and bearing with me. And I know it's early, but have a lovely Christmas, have a lovely break. Hopefully we'll all get some time out, Joanne. Yeah, a bit of relaxation would be lovely, wouldn't it? Because it's been full pelt. I don't know about you, but nightmarishly full pelt for me. So brilliant. Thanks, Selena. Thanks, everyone. Stay safe, and we'll see each other again in 2024, or come along on the 14th of December. It's free. Fiona will be sharing with you her views. We might also have a sort of refresh, and if there's anything else that we've found out about things, we can share that too. Thanks, Zara, as usual. Lovely to hear from you. Thank you, Sue. Everybody else, all the best. Thanks, Christopher. Stay safe and have a lovely time. Thank you. Bye-bye.